Good afternoon. My name is Jeff Tannenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. Welcome to our program today entitled Nonprofit Chapters and Affiliates, Key Legal Issues, Pitfalls, and Successful Strategies. We have a nice group joining us here for lunch in D.C., and we have a really nice group of, I think, about 150, 175 folks on the telephone on the webinar here today across the country. So welcome. As you know, this is part of our monthly luncheon series on nonprofit legal issues that we've been doing since April of last year. We're getting a lot of great feedback on these programs. There is, by the way, an evaluation call it an evaluation form. It's a few quick, simple questions on the confirmation or the follow-up email you'll get tomorrow. If you could take advantage of that and let us know your thoughts, tips, suggestions, ideas for upcoming programs, that would be greatly appreciated. Today's topic is one that everyone in our nonprofit group spends a lot of time counseling our clients on. For every nonprofit that has chapters or affiliates or other types of components, the relationship with those entities poses a very wide array of complex legal issues that we are thankfully very fluent in. There's lots of different arrangements that we're going to talk about that nonprofits can have with chapters, affiliates, and other components. And the structure of those relationships very much dictates the legal risks and pitfalls and other things that you can do to help protect your organization and minimize legal risks. We're going to spend a lot of time talking about those things today. We are fortunate to have with us two of the superstars of our nonprofit group here as our featured panelists today. To my immediate right is George Constantine. George is a longtime leader in the group with myself and is also co-chair of the firm's regulatory practice group. George has been working in the nonprofit and associations area his whole career and got his start as in-house lawyer at the American Society of Association Executives and has been with us ever since. To his right is Janice Ryan. Janice is an associate in our nonprofit group, a real rising star within our group, spends all her time working with nonprofits, but spends a lot of her time on chapter and affiliate issues as well. And George and Janice are going to bounce back and forth today and give you a lot of, I think, very useful, insightful information. Logistically, we want to encourage those of you in the room to ask questions throughout the program. Just raise your hand when you have questions. I might not call on you immediately if one of our speakers is in the middle of a particular train of thought, but we will get to you. Our speakers will repeat the questions. For those of you on the phones, you'll be able to hear those. And then for those of you who are on the webinar, pose your questions through the chat feature on the webinar software. I'll be monitoring the laptop in the front of the room, and we'll pose those questions to our speakers at the appropriate time. Sometimes I may answer your questions directly, and other times I'll pose them to the speakers. But definitely, I'm sure you're going to have a lot of questions, and feel free to throw them out at us. Handout materials, those of you who are in the room have a handout booklet that has a printed copy of the PowerPoint presentation along with some supplemental articles that we've written in the past on these topics, along with speaker bios. Those of you who are on the webinar as part of your confirmation email, you should have a copy of the PowerPoint slides, and then everyone tomorrow will get a follow-up email that will contain the slides, the additional articles and other resources, and also a link to a recording of the program, which you should feel free to share with your colleagues and others who might be interested in it. Preview of some of our upcoming programs that we have scheduled. We actually have 3 programs scheduled, just nailed down 2 this morning. Next month on August 2nd, we have a very interesting program called How Nonprofits Can Raise Money and Awareness Through Promotional Campaigns Without Raising Legal Risk. On September 13th, our program is going to be entitled Litigation Basics for Nonprofits, What to Do When a Complaint or Subpoena is Served, and Other Tips and Strategies. And finally, in October, on October 16th, our program is entitled Pouring Over Your Foundation, Making Sure Your Nonprofit's Directors and Officers Insurance Coverage Matches Your Expectations, and vice versa. Should be a terrific set of programs coming up. Hope you can join us for all of those. And if you're in town, definitely feel free to come by for lunch from 12 to 12:30, always complimentary, of course. With that, I'm going to, without further ado, I'm going to turn it over to George to get us started. George?
Thanks a lot, Jeff. Where am I aiming this? Oh, I'm sorry. I forgot. Okay. Welcome, everybody. Janice and I are going to do a kind of bouncing back and forth sort of presentation, so we're both going to kind of stay seated throughout. As Jeff said, really would encourage questions as they come up. Hope to answer those as they're top of mind for us and you. So feel free to ask away. What we're going to talk about today briefly are a number of different affiliation structures, the ones that we're most familiar with. Janice and I do a lot of work with associations and other nonprofit organizations that are national in scope and that have relationships with chapters or foundations or for-profit subsidiaries or other affiliations. So we're going to kind of talk about that broadly and go over what we're most used to seeing, and then after that going into where those legal risks are when you do engage in those sorts of affiliations, and trying to hit on some very specific ones. While there are plenty, we're going to focus on the attribution of liability as a national, for instance. Are you liable for what happens at your chapter event, and will you have to pay for that incident or that accident or that problem that happened at that event? IP ownership and use. There's obviously trademarks and copyrights that each of us as an organization have and would probably like to share with our affiliates, but only pursuant to certain terms. So we'll go over how to protect the intellectual property that you have. Antitrust considerations, particularly an issue with associations, but also with other nonprofits as well. And then, perhaps a quasi-legal management issue to end with, those governance-related challenges that can happen dealing with affiliates. I will say at the outset, as I'm going through what we're going to talk about, we'll probably slip into jargon and talk about chapters or foundations or something along those lines. We are talking broadly about affiliates, and so please forgive us. I'm sure we'll do it from time to time, but the goal here is to kind of cover the gamut of relationships that an organization can have. Then we'll go into some of the tax issues involving working with affiliates, and then finally, what I think is our kind of closer with a risk management perspective is, addressing these issues in a way that minimizes your legal risk and that manages the relationship properly, and talk about things like affiliation agreements, bylaws, articles, and other ways to apportion risk properly. Okay, so let's start with the common affiliate structures. There are a number of reasons that an organization may want to get an affiliate, get a chapter program set up, get a foundation, align with a like-minded organization. First is you have certain tax restrictions as a nonprofit organization. Depending on your organization's tax status, if you're a 501c3 organization, there's a limited scope of things that you can do. You have to be publicly beneficial, advancement of education, health, charity, those sorts of things. But you may also have a goal of being very active in the public policy arena. Well, as we all know, charities are allowed to do some lobbying, but not a substantial amount. So frequently a 501c3 organization may wish to establish a 501c4 affiliate to be more active in doing just that. You can even go one step further, and you've seen the examples of 501c3 organizations having a 501c4 affiliate plus the 501c4 then having a political action committee, which would allow the organization or allow some connection with the political realm, which 501c3 is banned from doing. So there's the tax restriction reason. There are also the fundraising opportunities reason, and this is more from the flip side. If you're a 501c6 association or some other non-501c3 organization, you have limitations as to how you can solicit funds. You can get sponsorship revenue, you can sell ads in your magazine, you can do all sorts of things, but the contributors, or the buyers of that product or service, have no ability to take a charitable tax deduction for their contribution. So you may want to have a foundation for that benefit. And perhaps more importantly, for a lot of the 501c6s out there, for instance, is to have a foundation also can qualify for certain government and private foundation grant money, can also have a kind of a halo effect, I guess, on some of what you do to be able to show that you have a charitable arm or an activity that's kind of apart from the industry activity. So having an affiliate could maximize your fundraising opportunities, could also maximize your resources. In situations where you have a activity that perhaps another entity is doing a very same or similar thing, very often there will be an affiliation agreement that's that's put together for a joint trade show or a joint activity, that all of a sudden we've got economies of scale here, and as an affiliate we can share employees, or we can share office space, or we can share overhead, and really lessen our expenditure on those activities. For chapters, geographic focus is huge. Obviously, you may want to get more close to the ground in terms of your members, or if you're a charitable organization, your donor base and the activities on a very on-the-ground, state-based, local-based connection. And to have that geographic closeness, you may wish to establish some network of chapters or components. And finally, probably most important for the lawyers, is managing liability exposure. If you do this right, and we're going to talk about how to do it right, you can circumscribe liability in those affiliates and have it not flow to you as a national organization or parent organization, or whatever you want to call it. So a lot of reasons to affiliate, and many of you probably in this room have already taken that step, and it's not a consideration of whether to, now it's how to manage. The structure, this is a very simple diagram, but I think it encapsulates it very well. If you're going to affiliate, there's a tension between the amount of control you can have over your affiliate and the amount of autonomy that the affiliate will have. And with more control, more oversight, more ability to, say, name directors, or require approval of bylaws and things like that, the more control and oversight that you as an organization have, obviously the less autonomy flows to the chapter or other affiliate you'll be dealing with. A lot of the decision making on this as to how to structure a good relationship is going to depend on kind of a close look at the goals of your organization, what you're hoping to accomplish, and also your risk tolerance. And there's different kinds of risk here. On the one end, with more control, you have some risk that we'll talk about later of having the liability flow to you, and therefore you're not circumscribing the liability. On the other hand, with more autonomy to the chapters or other affiliates that you're working with, the more possibility of the off-the-reservation example where someone starts using your name and logo or resources or goodwill in a way that the national doesn't particularly care for, but due to the lack of control and the high degree of autonomy, there's very little you can do about it. So it's a balancing act, and it's something that takes requires a hard look at the outset to make sure that you've done that well, and it will structure the relationship in a way that that fits these goals and risk tolerance. Like flipping three things. All right. So what we've done is, it's somewhat arbitrary, but we've decided there's kind of three large general buckets that you can place the types of affiliation relationships that we see into. But it's really more of a continuum than three separate buckets. When you talk about that control, autonomy dynamic, there are any number of spots on that line that you could place your relationship. But I think for ease of discussion, there are certain ways to group them. And what we've done is, the kind of the three that we've come upon here is, one is a fully integrated relationship where you have no real separate legal existence for your affiliates. We have a number of clients that have chapters or special interest groups or other things that they kind of put out to their members or donor base as separate or unique or a little different from the organization. But the reality is, legally, they're part of the organization. There's no separate legal existence, and the organization knows that and undertakes certain risk management oversight to make sure that whatever activities are being done under that name are being done pursuant to good policies and procedures. The second bucket that we've kind of described here is more of a parent-subsidiary relationship, where they truly are separate legal entities, but there's a organizational control that's beyond a mere contract with the affiliated organization. This is often the case with foundations or affiliates that are not geographic in nature. You'll often see this sort of relationship. The way it normally works is there's some tie-in with the bylaws or articles of incorporation of the affiliated organization. So as you know, each separate corporation has its own articles of incorporation, its own bylaws. where you see the parent-subsidiary relationship come into play most often is there's some ability for the parent to be perhaps the sole member of the affiliate, so that the parent actually has voting rights and the ability to install new directors, for instance. There's also what we've seen, that plus the ability to approve bylaws revisions, articles of incorporation revisions. The relationship and the oversight and the control is baked into the documents themselves. So while there's often then an affiliation agreement or a contract, and we would recommend that there be one as part of this relationship, the true control and the true oversight happens in those organizational documents. And it's interesting to see. I mean, really you think, well, how can you have we're talking mostly about nonprofit affiliates. How can you have a subsidiary that's a nonprofit? I mean, isn't the idea of a nonprofit is that no one owns it? Well, it's shorthand. The reality is that in most nonprofit corporation statutes, members of a nonprofit corporation are very much kind of akin to shareholders of a for-profit corporation. So you don't really have ownership, but you have control through that membership role.
And George, let me just add, of course, sometimes you have a nonprofit having a subsidiary relationship with a for-profit company. Very commonly used, George and Janice will talk about this to a certain extent, but a relationship where the nonprofit owns the stock of a for-profit corporation, either in whole or in part. Very widely accepted by the IRS, commonly used structure. And there, the control is exercised through the stock ownership. So if the parent nonprofit owns 100% of the stock of the taxable for-profit subsidiary, then it has the ability to appoint officers and directors and revise corporate, approve if it wants the revision of corporate documents and things like that.
Exactly right. And we'll hit on some of those issues too. And it's often a very beneficial structure if you've got a lot of unrelated business activity and want to, obviously you're going to have to pay tax on it through the for-profit, but you can shield your organization from the risk of loss of exempt status by doing that. The last bucket that we have here is what we call contractual affiliation. And a lot of the chapter relationships that we see may not have that parent-subsidiary oversight that I was talking about with the governing documents, but will have a very comprehensive, or should have a very comprehensive affiliation agreement whereby the chapters or affiliates agree to certain restrictions and reporting requirements and keeping with the mission of the parent organization. And in exchange, there's the benefit of the affiliate often being able to use the name and logo of the parent organization, also some form of share of dues or some form of share of donations or other license back and forth in terms of the intellectual property that the national owns for the chapter or other affiliate. Obviously, for circumscribing liability, it's best if those affiliates are separately incorporated, but it's not always the case. And you will see situations where, particularly in the geographic end, there's a lack of that incorporation. And we'll get into why that can present some risk. Okay. So I kind of talked a little bit about this on the last slide, but now that we've talked about the buckets that we put these in, what are the risks associated with each type of organization? A fully integrated organization, you're really nothing more than a department or a program of the national organization. So as the example I gave is special interest groups. There's a lot of membership organizations that will offer special interest groups that are based on particular focus, again back to the association example, particular focus of the industry or profession represented by the association. And they present themselves as the XYZ Association Intellectual Property Special Interest Group or the XYZ Association Widget Special Interest Group because we focused on that. But the reality is it's all part and parcel of the activities of the organization. It's going to be considered the activities of the organization. Liability will flow 100% to the parent, in which case, I mean, you should implement good risk management protection knowing that going in. For the parent-sub relationship, you have a separate entity, and the subsidiary is truly treated as a separate entity unless you don't do the things we're going to recommend that you do. So the parent should not be liable for the activities of the subsidiary, but there is this ability, what we're going to talk about, things like called piercing the corporate veil. If the organizations are too close and there's too much control, you could risk having the liability flow to the parent. And in a contractual arrangement without the parent-subsidiary arrangement, similarly, the parent's generally not liable if done properly, and the risk of liability flowing to the parent is, I would say, somewhat less than the parent-sub relationship because there's not that baked-in connection that you see in a parent-sub. But still, if there's no separate incorporation by that affiliate, you can be certain that a plaintiff or whoever else is a person who signed a contract with the affiliate, whoever else feels harmed by that affiliate, if there's no separate incorporation, you can be certain that the parent will be named in those papers, and there'll be some battle on the part of the parent organization to get out of any of that litigation by saying it's not us, it's them. Corporation presents a great, convenient shield against that, and it's very difficult to get beyond incorporation. But if there's no separate incorporation, that sort of liability flow is possible.
And of course, as we're going to talk about later, even if there is separate incorporation, that in and of itself doesn't create some absolute liability shield. And it is very common, as George and Janice will talk about, for two separate corporations that are affiliated, for one to be sued because of the acts or omissions of the other. And what we're going to focus on is things that you can do to help minimize the risk of losing such a lawsuit.
Yeah, that's correct. And I didn't mean to give that impression. Obviously, some of the examples we're going to talk about, there are separate incorporation and still the liability is flowed. And it's all about these factors. It's a number of factors to consider, and we'll go into those. If you're too close, if there's too much control, and a lack of observance of true separateness, that's a real risk that's out there. Just getting into just a few other characteristics for each of these types of organizations. As I said, the fully integrated, you see a lot with special interest groups and other forms of organizations may do it with their chapters that are geographic based, with the understanding going in that they're liable for the activities of the organization, that they got to report it on their tax returns, et cetera, et cetera. And so there's, in an ideal world, there's good oversight. The benefit of that approach is there's a lot of administrative burden that goes into being a separate entity, being a separate corporation, and there is things like we talk about in the tax-exempt world, the Form 990 obligation, perhaps if you don't go the group exemption route, perhaps even applying for recognition of exempt status, and then there's ongoing corporate reporting requirements in the particular state. And frequently we've, excuse me, been called in to represent organizations that have taken a closer look at their chapter structures, for instance, and have asked us to look to see kind of the status of the chapters throughout the country. And lo and behold, a good number of them will have been administratively dissolved by their state because they haven't even filled out the annual reports for their particular state require. And it takes a lot to get administratively dissolved, and it takes a number of years to fail to file those annual reports, but it happens more frequently than you would think. And those sorts of, and now with, and we'll talk a little bit about this, but now with the automatic revocation of exempt status, for those who fail to file 990s for 3 straight years, we're seeing that happen with a lot of affiliates and chapters. If you ever check out that list that the IRS publishes from time to time of administrative or automatically revoked organizations, you'll note that a lot of those are chapters. A lot of those are affiliates or chapters of recognizable national nonprofit organizations. Other characteristics of a parent-subsidiary relationship. Like I said, you see this very often in an association-related foundation context, or maybe a foundation, or maybe a 501c3 with a 501c4 affiliate. Sometimes you will see that in a chapter context as well. It does help very much with control when you know that ultimately the national organization has that final say based on removing directors who may not be towing the party line and reinserting directors that may be a little more friendly to their thinking. Finally, the contractual affiliation model. You see that with federations or associations of associations, for instance. Very often it's a strong affiliation agreement or a charter agreement or something along those lines. This can kind of vary the degree to which and the detail which your contract requires the chapters to engage in certain activities is going to vary based on those assessments that we talked about earlier, and also, frankly, on the kind of the power and sway of the affiliates. I think as we get into some of this discussion, we'd love to hear your thoughts as well. When we've been asked to investigate or help out with perhaps a new chapter relations agreement or chapter charter or affiliation agreement, it's seldom a smooth process because the chapter leaders frequently will have a certain suspicion that National's trying to shove something down their throats that maybe they don't want, or that's beneficial to National but not for the chapter. And here's Big Bad Washington or wherever you happen to be based, big bad Washington coming down on us and making us do all this stuff. So the contract that results from those sorts of discussions, I'll talk about some strategies that I think have worked in the past, but the contract that results from that sort of dynamic, is often a, very much a negotiated deal. Even though we're all part of the same family, the chapter leaders have different interests and different concerns, and they're obviously more focused on their particular area. So the contract's going to reflect that. One point that we'll keep repeating is if you are going to go the route of treating an organization as truly separate, the lack of incorporation, as Jeff talked about before, is not a good thing. If you can have separate corporate status for those chapters, that goes a long way to circumscribing liability, although not all the way. So with that, I'm going to turn it over to Janice. I'm going to talk a little bit about the specific legal issues that we're encountering here.
Thanks, George. So the first legal pitfall that we're going to talk about today refers back to our first slide, which was, why are we going to have affiliate relationships? And as George mentioned, oftentimes the most important factor will be a desire to manage or minimize your liability risk associated with whatever activities that the two organizations want to carry on. And assuming that this is one of your goals, you've likely made the choice against a fully integrated structure. And so here we're talking about some sort of structure where you have separate entities coming together, whether that be in the nature of a parent-subsidiary model or just a contractual affiliation. And so the first area that I think is worth addressing is this issue of having unincorporated affiliates. As George mentioned, you can kind of get into this legal gray zone when you are contracting with an entity that is not formed as a corporation under state law. And the problem is that under common law, an unincorporated entity really has no separate legal existence. It presents risk on two fronts. One is for the people on the ground at the affiliate who are carrying on the activities. They may face personal liability if they enter into a contract with a vendor to do an event. The vendor might be able to seek to hold that individual, whoever signed the contract, personally responsible, or perhaps all of the group together personally. And then the other risk, which George highlighted earlier, is that when an affiliate is not a corporation, it is very likely that a plaintiff or a vendor will seek to hold the parent entity liable on the basis that the parent probably has more resources than any of the individuals involved on the ground, and they will have perhaps an easier time of conflating the two organizations if the affiliate doesn't have that formal corporate structure that is so well established in the law today. There are probably about a dozen states that have adopted what's called the Uniform Unincorporated Nonprofit Association Act. And in those states, this group, this unincorporated association of people working together, will have separate legal entity status. The entity can own property, enter into contracts in the entity's name, and the individuals will not be held personally liable for the contracts and liabilities of the entity. But it's a very narrow group of states, and for the most part, unincorporated associations are going to be subject to this hodgepodge of common law standards. So as a matter of prudence and conservatism, we usually recommend that the affiliates be separately incorporated.
The question is whether the 12 states that adopted the nonprofit, Uniform Nonprofit Unincorporated Associations Act.
I do not know them off the top of my head, but no.
Just email us offline and we'll get back to you.
We'll get it.
There is a website, the Uniform Law Commission has a website that's very helpful. They track the adoption of laws promulgated by the body in all the states, so they have nice little maps, and you can look that up.
And that doesn't mean there's only 12 states with a Unincorporated Associations Act. Some states may have them, but they're just not uniform.
That's right, and some states may have developed through case law some rules that will provide some sort of limitation on liability for members. But it's just a case-by-case basis, and it's not an easy way. If you're going to operate on a national level and you're going to have affiliates in all states, all states have corporation statutes. There's a substantial body of case law, and courts are familiar with the idea of limiting liability through creating a separate corporate entity. And as a general rule, it's a more robust protection in terms of minimizing your liability.
Agreed.
To tee off that, one problem that can arise in terms of maintaining and honoring your separate corporate entity status, or if it's not a corporate entity, just another entity, is this failure to observe what we call corporate formalities. This seems like a very simple thing, but you would be surprised at how many people say, oh, it's so simple, it can't be important. But it really is important for the entities to have separate boards and officers. It doesn't mean that there can't be overlap, but that there would be people responsible for each entity, and that they will have separate meetings, and that they will record their decision making through separate minute books and record books. This will go a long way and can be a factor if a court is trying to determine whether the two entities are truly separate. This will go a long way toward the separateness column. And then the final area is something of a challenge, especially as George depicted on that first slide where we talk about, the balance between control and autonomy. When you have a separate entity, the goal here is not to necessarily run that entity, be so involved that you're making decisions for the entity on a day-to-day basis. Because if you do operate in that way, there is some risk that a court will disregard the separate entity status and find that the two organizations are really operating just as one. And there are lots of factors. It's a multi-factor kind of test. There isn't going to be any one particular indicia of control that will tip you over the edge, but perhaps a combination of factors could become problematic. If there is complete overlap of the boards of directors and the officers and employees are all the same people, and there's no honoring of corporate formalities, if all of the funding comes from the national or the parent entity, if you start adding these various factors together, you will have a harder time trying to justify the separate entity status. I think from my perspective, the key is it's perfectly fine to have some overlapping directors and to have basic guidelines for operations, even to have a veto on certain decisions. But you get into a real danger zone when you start when you're involved in the day-to-day activities. And I think the one additional point that I would make is that you can look at this in a global way in terms of, okay, well, does the parent entity absolutely control all of the activities of the affiliate? But you can also get into liability on activity-by-activity basis. So, if an affiliate calls you with perhaps an employment problem, they're considering firing a staff person, and the affiliate calls the national entity and asks for advice. If the national gets really involved in that firing and hiring decision, whatever it may be, there may be some employment law liability that flows back to the parent entity. So you can look at it on sort of a global basis, but also on an activity-by-activity basis.
And one point to be clear, that doesn't mean also that you can't share office space or you can't share employees or you can't share overhead. It all needs to be properly apportioned and accounted for so that timesheets and those sorts of things, so that the deal is memorialized in a contract and affiliation agreement. But just anecdotally, we will often be contacted by a organization whose foundation or this or that affiliate has has seen the light on the separateness issue, but has kind of gone overboard on the other side, and really what's at play there is probably more of a power struggle than really a legal risk on corporate separateness. And we've been approached, well, they say we can't share office space anymore because, all of our liabilities will flow to you. And I say, well, it's nice of them to be concerned about our liabilities, but the reality is that we can handle this properly, and that's not going to appreciably increase the risk. Those corporate formalities things, though, is a real issue, and things that you think you would do without thinking, like a separate bank account. That's where you see courts saying, well, you've mingled funds, you've got no attribution as to who's paying for what, your boards are the same, those sorts of things. That will get you into more of a hot water.
That's right.
So let me just ask, and to be clear, that scenario you described is for separately incorporated subsidiaries. First question. The second question goes back to this example about the labor law question. So let's say there's an attorney and a parent, and there's these separately incorporated subsidiaries, and they call up for some kind of legal advice. Is the attorney and the parent acting as a law firm to those separate entities, or is that an in-house counsel kind of relationship? In other words, would they have to carry malpractice for that or not?
Okay. Well, just to try to encapsulate that for those listening, I mean, the first question had to do with the what we're talking, just clarification. When we're talking about these risks, we're talking about a separately incorporated situation, be it parent sub or just contractual. Yes, that's the case. Although, I mean, the risk could flow with unincorporated as well. If you're trying to treat them as separate and they're unincorporated, I would say you have a lot more risk that whatever happens with that unincorporated association flows to you. Right? I mean,
I think that's right.
The second question is an interesting one, and it has to do with Janice gave the example of getting advice on an employment law issue. What if you add to that hypothetical that the advice is coming from a lawyer for the national, and could that implicate? And I may be shortening this too much, but could that implicate? Actually the practice of law issues, that you've got an employed lawyer of one entity giving advice to one that you try to hold out as separate. I think technically from the legal ethics perspective, there are some points that you need to be careful about in terms of representing an affiliate that's separately incorporated, but that happens very frequently with interlocking organizations. I don't think the fact that a lawyer is involved with an affiliate that's a subsidiary necessarily means liability flows to the national. But I don't know enough about the regulation as to whether that means the national becomes a quasi law firm as to the chapter. It could implicate privilege, though. I mean, you could say, well, this is not a privileged communication because this chapter or this affiliate is not your client. So I don't know. I don't have an answer. I have more kind of points to raise there.
Yeah, and let me just make a note. I'm concerned if we get too much into specific questions about specific factors and how those lessen or increase liability risks, that we're going to kind of be getting ahead of ourselves. Maybe we should try to get through a little bit more of the basics in the program, and then we can get into some real specific scenarios. I have one such question from the webinar, but we'll hold that for a little bit.
Okay. On to the next one?
Yeah. So the next area that we'll talk about that is a really important legal consideration is intellectual property. The most prominent pitfall, I guess, here involves use of names, logos, and other trademarks of the entities. It's a very common practice for an affiliate for the affiliate's name to include the parent's name. And this can result in disputes when relationships go sour. When the parties decide they want to break up, and both entities have been using these names, and the affiliate perhaps will want to continue to use its name, and the parent would prefer for the affiliate to not use the name any longer. usually the parent entity will have superior rights to the name, particularly if it's a national organization, and they've taken proper steps to register their trademark and done all the things that they could possibly do to protect their rights in the name. But that's not always going to be the case, particularly if, for example, the entity, the affiliate that's disaffiliating is long established, they've used the name for decades, and the parent entity has, in a way, slept on its rights, not taken quick and prompt action to protect the name from unauthorized use. When you get into those situations, courts may be less willing to prohibit the affiliate from using that name going forward, even though the relationship is over. So it's really important to, and we'll talk a little bit more about this toward the end of the presentation, we talk about affiliation agreements, but it's important for organizations to specify trademark license terms in their affiliation agreements, or perhaps in some manner through their governing documents, and to carefully consider whether it's in the organization's interests to formally register their trademarks and take the benefits that come with registration. And for organizations that are interested in or thinking of operating internationally, it's also important to keep in mind that your U.S. registrations are not going to be sufficient to protect your marks in those other countries. And it's important to look into registering or at least at the outset searching the trademark registration laws of the particular countries in which you're interested in operating.
And as we discussed at a seminar we did a few months ago on international legal issues for nonprofits, unlike in the U.S. where an organization can acquire common law trademark rights merely from usage, which is one of the reasons why we recommend, for instance, that a national association register its trademarks federally, because a state association that's using the name could acquire over time common law trademark rights, and it helps to better protect the national. But internationally, in most countries, there is virtually all countries, there's no such thing as common law trademark rights. You only get rights from registration, which is why it's so critical if you're going to be creating, say, international chapters or affiliates, and letting them use your name, your logo, your certification mark, or other marks. Or if you're simply going to be doing it yourself overseas, that you register your marks in those countries right off the bat. Otherwise, someone else can come along and be first to file, and you can find yourself out of luck. One other comment on what Janice is talking about in terms of intellectual property and trademarks in particular, we generally will strongly recommend to, say, national nonprofits that have state or local chapters or affiliates, that of course for the whole idea of a chapter model or a federated model or something like that is that there's this consistency, and so you're going to have the same core name and logo as part of each state and local or regional chapter and affiliate's name. But what we almost always strongly recommend is that you don't allow the state or local or regional chapter to simply use the national's name and logo, but that you have a special version of that created that clearly delineates the state or local or regional group from the national group. Too many organizations they fail to do that. State and local groups simply use the same name and logo as the national. Maybe they have their own little slogan somewhere, maybe not, but that can create real confusion amongst the public as to who is the real provider of the goods and services that are being provided, and we have found it to be a primary trigger in lawsuits governing situations where the injured party believed, or at least they claimed to have believed, that the state and local group was in fact the national group, or maybe just part of the same legal entity and not truly a separate legal entity. So one of the best ways to guard against that is when you provide that trademark license to the name and logo as part of your affiliation agreement or otherwise, that you have a special version created and you mandate that the state or local group can only use that special version that has the word, state chapter or whatever it is in there to delineate from the national group.
Thanks, Jeff. The other area here that needs to be considered is pertaining to copyright primarily. Both groups probably have membership lists. Perhaps there are databases that you own and you want to be able to allow each party to use them as activities are undertaken. You may create publications, perhaps websites, things, creative works, and it's important to document clearly for both tax reasons and for some of the liability reasons that we've been raising throughout the presentation of who owns those assets and what are the terms of use. How are we going to allocate any revenue streams that come from them? On the tax front, and we'll talk about this a little bit later, before assigning, especially if you have relationships with a 501c3 entity, before assigning C3 assets to a non-C3 entity, you have to take a really close look at the tax implications, and we'll discuss some private benefit issues a little bit later.
Okay.
The next area that we're going to discuss is antitrust risk. Antitrust is a real legal pitfall, particularly for trade associations or professional societies, because by their very nature, they are groups of competitors. The primary antitrust laws that will be applicable to associations or any really group here is the Sherman Act. Section 1 of the Sherman Act prohibits illegal monopolization and agreements in restraint of trade. And the Federal Trade Commission Act, Section 5 of the FTC Act, prohibits unfair methods of competition. We've highlighted 4 areas here on this slide that particularly relate to the interactions between affiliates, but these are by no means all of the antitrust risks that are out there to nonprofits. The first one that I'll talk about is this price restrictions issue. Agreements to fix prices are per se violations of the Sherman Act. They are always going to be considered anti-competitive and should be avoided at all costs. One of the things to consider in this area, as we've been talking about this idea of corporate separateness or parent-subsidiary relationships, is that there's a defense to the Sherman Act. It's called the Copperwell Doctrine, which says that a parent and its wholly owned subsidiary, this is in the for-profit context, mind you, are not legally capable of conspiring. They can't enter into an agreement to fix prices in violation of the Sherman Act. And that principle has been applied in the nonprofit context between a parent and a related entity, a related chapter. So you do have some of that defense potentially available to you. But the bottom line is that if your affiliate is engaged in some sort, the members of your affiliate are engaged in some sort of agreement to fix prices and the national participates in that, the national will be just as liable for that activity if it's engaging in it. So price restrictions are a problem. The next area is territorial restrictions. It's very common for a national organization that operates in all 50 states, perhaps at the local level as well, to establish affiliates that are restricted to certain territories. And the organization won't establish another affiliate in that territory. So perhaps you have one affiliate in the District of Columbia. You won't have 2 affiliates in the District of Columbia. That's perfectly fine and legal, but organizations need to be really careful about trying to prohibit your affiliate in that jurisdiction from offering goods and services outside the jurisdiction. If you try to restrict the ability, let's say you're a professional society and your members are healthcare providers of some form, if you try to say, okay, healthcare provider, you cannot offer your services in any other jurisdiction but this jurisdiction, that will be an antitrust violation. The next area to discuss here is common membership requirements. For membership organizations, especially those that operate at many levels, it's not uncommon to require that a member be a member of a local chapter, a state chapter, and the national, and that you must be a member of all 3 or you can't be a member of any. This is common, and it's actually unlikely to present significant antitrust risk. There has been at least one reported case where a claim was made that this was an illegal tying arrangement. And an illegal tying arrangement is something where one party uses market power that they have over some particular product or service that a consumer wants to buy, and they use that market power to get you to buy something that you don't want. And the court in that case ruled that it was not an illegal tying arrangement for an association to require membership in all three of the entities. And there were various reasons for that. But done properly, this shouldn't raise significant antitrust risk, but claims have been made. And then the last piece comes back a little bit to what I was talking about earlier with price restrictions, which is to the extent that an affiliate is engaged in anti-competitive activities, whether it's price fixing, bid rigging, some of these, a boycott, various activities that are considered anti-competitive, to the extent that each entity is participating in that activity, each entity will be held liable under the, or can be held liable under the antitrust laws. The next area that we're going to talk about does overlap a little bit between legal and non-legal considerations, but a substantial part of what George and I and Jeff and I assist clients with relates to governance-related challenges that organizations have in terms of their affiliate relationships. The first item that I think is an interesting one involves fiduciary duties and overlapping directors and officers on the affiliates. The fiduciary duty of loyalty is usually described in grandiose terms in case law, and it is this undivided, utmost loyalty that a director owes to the corporation that they serve. When a director serves on the board of a parent organization and a subsidiary organization, or perhaps an affiliate representative is elected to sit on the board of the national organization, there is and can be this inherent conflict of interest that arises. It doesn't maybe present itself in all matters, but there may be times when, for example, if the board of the national and the affiliate are considering the affiliation agreement, well, whose side are they supposed to advocate? Whose interests are they supposed to be looking after? Unfortunately, there isn't really much case law in this area to give us guidance on what the right answer is, but I think it's something for organizations to be cognizant of and, to the extent possible, try to work within the conflict of interest policies that you have and manage them appropriately.
Yeah, and that comes up from time to time, and I think it's also important to remember that sometimes you can go overboard in terms of seeing potential conflicts in every decision that's being made based on the fact that, well, this has some effect on all affiliates, et cetera, et cetera. And I think should remember that very often the interests of these organizations are completely aligned. So, I would find that it will come up in a transaction by transaction basis occasionally, but it shouldn't. The takeaway shouldn't be that there's some inherent problem with overlap because of that. I think the conflict of interest policy and following it closely is the best way to do it, but not to let it flow into a constant discussion or a constant issue.
One other thing I'd add to that. One thing that is clear in these situations is that if you are a board member of a corporation, say in this case there's a national association, it's got its board of directors, and some of the board members come from state affiliates, so they are the paid chief staff executives or the chief elected officers from say a half dozen of the state affiliates, and those rotate on a regular basis. Or maybe all of the state affiliates have a representative on the board. We've certainly seen that model. It can be very unwieldy from a governance perspective, but we've seen it. In those situations, the law is very clear that each of those directors on the National Nonprofit Organizations Board owes a fiduciary duty to that national association, to the entire entity. And even though it may be there in effect as a representative of that state association, it needs to make decisions and act and vote as to what it believes is in the best interest of the entire national association, not just its state affiliate. And we have seen this create some real issues and problems in a number of situations, particularly where in situations that, like George said, not very common, but they do arise, where the interests are not aligned and the state association feels very strongly and opposite from what most of the rest of the national association wants to do. And it's even gotten so bad that when I've done a number of board orientations and whatnot, the CEOs have asked me to remind everyone that all the directors that they owe the fiduciary duty to the entire organization. And that's something that you might want to consider putting into your policies, board governance policies as well.
That's a great point. I mean, sometimes the boards themselves will fall into that trap and think, well, you're from the Northwest chapter. What do you think? And you're informed by that as a representative, and that's where you come from. You don't forget all those things, but it should be constantly upfront that the fiduciary responsibility for each director is to that organization.
The next area that commonly causes some challenges for organizations is whether the affiliates will all be required to have the same governance structure. And it depends on your organizations, but usually the organizations don't do all of the same activities. And a common governance structure may be overly burdensome or restrictive based on whatever the activities of the organization are. So for example, if you have affiliates that are smaller, maybe they're just volunteer run, there's no professional staff, using the parent's governing structure in terms of maybe their board size, how many officers they have, the term length for the board service or for officer service, it may not be the best fit for that smaller entity. We see a lot of times problems coming because the pool of volunteers is not large enough to sustain a very large board, or there aren't enough folks who are really interested and available to serve in officer positions. And so it may make sense to be able to provide your affiliates with some guidance, to provide them with template kind of governance options that they could choose from, but one size doesn't necessarily fit all. Common membership requirements I already touched on. One thing to consider in the governance arena involves what happens when a member is terminated from one organization. Do they automatically become terminated from the other one? When you have a requirement that says you must be a member of both organizations in order to be a member of any of them, what happens when one decides to terminate that member for let's say for failure to pay dues? It's really important that your governing documents specify what happens. If the goal is that membership will terminate automatically for failure to qualify midterm, then you're covered. If not, probably both organizations will have to take the step of formally terminating that member.
Right, and we've seen that come up time and again. So the bylaws for both the national or parent and affiliate should be consistent.
The next area to address here is just managing the ongoing relationship with your affiliate and their status. Organizations are dynamic, they grow, they change over time, they might be inactive for some period of time. Having some sort of policies or charters in place that dictate or set out reasonable expectations for all of the parties regarding what threshold is there for an organization to be an affiliate. Do they need a certain number of members? Do they need to be able to raise a certain amount of money? How do we resolve disputes between the affiliates and the national? Who gets to make the final decision? And most importantly, how do we go through a disaffiliation process? Do we have to have some sort of special hearing before the board, before making a decision? These are important things to have established up front.
Absolutely, yeah. That always need to plan well for when things may go awry in terms of the relationship.
And then the last piece is financial management. This is not always a legal consideration, but we do see it's very common to have some sort of dues collection arrangement where the national will agree to collect dues and distribute them to its affiliates, or some sort of other fundraising, revenue sharing arrangement, depending on what kind of relationship you have. It's important to have an agreement so that the parties understand what the flow of funds is, who has rights to access them, when are you going to get the money, when are you going to disperse the money. These are just important things to document so that you minimize any sort of dispute and confusion along the way. The other piece that we think is very prudent to deal with through an agreement is having or requiring putting down expectations about internal controls at the affiliate level. So we especially see this with smaller entities, but it's important that not one single person have control over the finances. If there is an expectation that there would be two people who have to sign checks over a certain amount, that's a prudent practice. You may want to have a bonding requirement for the treasurer. You may want to require that the person who is responsible for depositing checks and writing checks is not the same person who opens the bank statements. These are just things that can go a long way toward preventing problems that can arise in any organization when you have a single person handling all the funds.
Right. And that's a good point to kind of circle back with the issue of, well, we may not have enough volunteers for, the same structure as the national may have. But that doesn't obviate the need for good rotation in your officer slots and making sure that no one person, particularly someone in a sensitive spot like treasurer, gets to stay in there for very long. I think if you see, the reports that come out from time to time of fraud in nonprofit organizations and embezzlement and those sorts of things, invariably there's a lot of smaller state-based organizations that are focused on that, and over years it can amount to a lot of money. So while it's important to make sure that you have flexibility in the governance structure so that you don't have this massive overlay of requirements for numbers of volunteers and officers, et cetera, by the same token, some of those internal controls that Janice referred to would have a lot to do with making sure you rotate them in and you get good oversight.
And just for those of you interested in that topic, we did one of our monthly legal seminars on preventing and detecting fraud and embezzlement in your nonprofit at some point last year. And that, along with all of our seminars, you can listen to the recording and see the streaming PowerPoint on our website. If you go to venable.com/nonprofit/recordings, that's where we house all of those recordings, and you can get a lot of information on that topic. That was a very popular seminar.
Yeah.
You mentioned that an officer might stay in the position of treasurer for too long.
Well, the question is, how long is too long in the position of treasurer? There's common rotation cycles are, for many officers, for most organizations, are 1 or 2 years. There's no one size fits all here, but I think, if you're going on 3 or renewing for more than 3, you might want to rethink that. A lot depends on how good your controls are otherwise. If the treasurer is not in such a sensitive spot that he or she has got oversight the whole time, then your decision may be influenced by that. Okay, we're going to talk very briefly about group tax exemption, and there's no way to cover this in if we had even the full session time for it. So my apologies in advance for kind of going through just the highlights here. But it's a real important benefit, particularly with the national chapter relationship. As tax-exempt organizations, we all at one point in our lives as organizations went through the application, or most of us did, the application for recognition of exempt status. And particularly for 501c3s, that application is quite burdensome, quite time-consuming, and oh, by the way, it takes the IRS forever to approve an application that's been submitted. The beauty of the group tax exemption, in a nutshell, is that you get to apply once as a national for all of your chapters, and if all of your if you qualify from that application, you get to add your chapters into that group exemption without each of them separately applying for exempt status recognition. That's it in a nutshell. The way to apply and the process, as everything, and I'm not just bashing the IRS here for the sake of bashing them. They really have gotten incredibly slow on the application side of the equation. Some speculate it's because of these revocations that are happening with the automatic revocations, that there's just overwhelmed with new applications for these organizations that are trying to get into good stead again. But particularly on the group exemption front, there was actually a report from the Taxpayer Advocate that highlighted this. The IRS has become increasingly tight in terms of scrutinizing what they will give in terms of a group exemption application. From their perspective, they're charged with executing the tax laws, and overseeing tax-exempt status is a huge part of that. People get that tax deduction for being able to donate to a charity, or you get to not have to pay income tax on your net income. So they're not to stand in their shoes, but I think their argument back as to why they're scrutinizing these more closely is that you're going to have the ability as a national organization to just add organizations to exempt status without us, IRS, getting scrutiny on this. So we want to make sure as possible at the outset that this is going to be not abused. Some of the threshold items that need to be in place before you can apply. The central organization, which is the national organization that's doing the application, must first have its own exempt status, obviously, and it needs to have been recognized. Sometimes you have the ability as a 501c6 or C4 or C5 to self-certify as a tax-exempt organization. Well, the only way you get in as a central organization under the group exemption is if you actually have applied and been recognized by the IRS. None of the chapters are subordinates, and subordinate is the term of art that the IRS uses. None of those subordinates are able to be organized or operated in a foreign country. There can be no private foundations as subordinates as opposed to public charities. I won't go into any detail there. I'm happy to answer any questions specifically about that. Obviously the subordinates, once they're approved, should not be included. They shouldn't send their own application in. It wreaks havoc with the system. And there's certain elements that you need to include as part of your application. And one of the articles in the handout, I think it's the last article on the list, maybe not. There's only 3 articles there, but it's the one titled Changes in Store for Group Tax Exemptions with a question mark. Goes into detail as to what some of the other requirements for the application process are. Suffice to say that you need to show, as the central organization making this application, that you have some oversight or control over your subordinates, and ability to make sure that they're going to act in a way that's consistent with their tax-exempt status. In a way, as the national organization with a group exemption, you're stepping into the shoes of the IRS and validating, for lack of a better term, that these chapters or these subordinates, these affiliates that you have, are acting consistent with the exempt status that they have. And in your application, you need to show that. And what you need to do to show that is usually to show an affiliation agreement or some other form of control through model bylaws or model articles of incorporation, and that shows that you as the national organization have the ability to kind of have oversight over the organization. Yeah. Changes may be forthcoming. Well, because of that report that I just referenced from the Taxpayer Advocate Service, I'm sorry, it's not the Taxpayer Advocate Service. Anyway, it's an oversight group within tax-exempting government entities that did this report on the problems that they're facing with group exemptions. It may be one of the things that you can do as a holder of a group exemption is each of your chapters or subordinates can jointly file a group Form 990 as opposed to each having to file their annual Form 990. There seems to be some suggestion that ability may be going away. I have to say, in my experience, very few organizations actually do that, and they push the obligation of the Form 990 on each individual chapter. Usually these chapters are small. They can get by with filing what's called a Form 990N, or worst case, Form 990EZ, so the 990 process isn't quite as burdensome as it is for the national. Obviously, this is very beneficial for the subordinates. They don't have to do the application. That supervision or control is a little bit of tension with the whole separateness issues that we've been talking about. Obviously, by virtue of exercising that supervision or control, the national is, in a way, having some oversight or control over the organizations. It's a factor to consider as part of our liability risk equation. One limitation, that doesn't eliminate the need for the chapter to pay tax on its unrelated business income if it incurs any of that. Employment taxes, state and local use taxes, they're all still on the hook for that. The group exemption is only as to federal tax-exempt status. The compliance is largely with the national. The national should compel the chapter to help it out as part of its affiliation agreement. There are annual filings that go to the IRS where the national essentially gives a list saying, here are our subordinates that are on our group exemption for the year. And the national has its discretion to remove chapters from the list. So you may have and should have some standards for the chapter or subordinate or affiliate to follow, and failure to do that, they could have the jeopardy of being removed from the group exemption. Kind of a harsh penalty, but something that could be out there. Sure. That's a good question. The question is, what's the difference between the group listing that the national sends in and the Form 990N? I think in terms of the information that's provided, very little, but the requirements are still there for both.
Yeah, and another way to think of it is you have the group exemption, which covers simply maintaining the exempt status of the entity. Of course, you have that initial filing that George talked about where you have to provide a lot of information. Then you have the annual filing that the parent does that lists everyone in the group and additions or subtractions. And like you said, the information that's contained in the list is largely the same information on the 990N, but that is separate and distinct from the Form 990 filing requirement that is incumbent on all tax-exempt organizations, including those in a group exemption. And they still have to do that. That's a separate requirement, separate and apart. That's why even though it's the same basic information, it's all going to the IRS, two separate requirements. And the 990 requirement is on the chapters, whereas the other filing is done by the national.
And failure to file 990, as I said earlier, 3 consecutive years automatically ends gives a revocation, and you have to reapply to get back in. So obviously there's an obligation from a compliance perspective for national or central organization to do some monitoring to make sure the subordinates are acting consistent with exempt status. And to that end, it would be helpful and very much recommended for national to do training with the chapters, not just from strict compliance with the Form 990 requirements, but also just general training about compliance with 501c3 or whatever the section of the code that you're exempt under, compliance with that exempt provision of the code. Okay. A couple other tax considerations briefly. If you have a situation where the example that I've given a couple times now is the association with a 501c3 foundation. So the association parent is, say, a 501c6, and you have a 501c3 affiliate. The IRS will focus very closely on that relationship to make sure that each entity is in its lane, most importantly that the 501c3 is in its lane, and not using its assets and goodwill to benefit the 501c6 or the industry or the profession. So what we've seen, and we've had very close interaction with the IRS on one very tense but ultimately successful audit of a major 501c6 organization, is the IRS will view, if you're flowing 501c3 benefits to your 501c6 parent, I'll give one example. Having a 501c3 pay for a market research study as to your 501c6's kind of place in the market, and say your members are retailers of a certain variety, and the study has to do with the retail market compared to the internet market in that particular area. Well, that's an industry benefit. That is not a public benefit. That's questionable whether it could ever fit under the educational portion of 501c3. To do that, to gratuitously give the benefit to the 501c6 using the 501c3 resources jeopardizes the tax-exempt status of the 501c3, and the IRS would call it private benefit. Similarly, because they are closely related entities, and we don't have time to talk about the private inurement provisions, but they could also be viewed as private inurement. The other way, so oftentimes the foundation of an association, that relationship, may try to do a grant, for instance, to the 501c6 parent or some other non-501c3. It's not prohibited, but it's has to be done very carefully, and we would say the 501c3 would have to exercise significant authority over that grant to make sure that money is used specifically for a 501c3 purpose. Scholarships, for instance, to a public university would fit under that. But oversight in that grant, meaning that the recipient needs to actually report that the funds are used properly, and that should the IRS ever come knocking, the 501c3 can show that. Other forms of transferring resources from a 501c3 to 501c6 to protect yourself if you're not giving a grant, make sure there's a fair market value payment back to the 501c3. Make it a quid pro quo, transactional sort of relationship. It's very important if you have an interweaving of 501c3 organizations and non-C3s, a 501c4, 501c6, that the political activities of that C4 or that C6 stay entirely separate from the 501c3. The political activities, if they're attributed to the 501c3, the only penalty available to the IRS is revocation of 501c3 exempt status. And there's an article in the handouts I won't go into now that goes into what can happen if you're not properly separated. And in that example, the IRS found a website where the affiliates essentially shared the same frame around the website. Now, each affiliate was identified separately within the frame, but the frame was the 501c3 organization. Make a long story short, the IRS attributed all of the content of those pages that were framed with the 501c3 information as attributable to the 501c3, including the political activities of a 501c4. So it's a good roadmap or a good, cautionary tale, I guess, to look to when you see how closely you are working with your affiliates. So now we're going to move into very briefly talking about addressing some of these risks through, we kept referring to affiliation agreements, charters, bylaws, governing documents. We want to kind of hit each of these points in this diagram here are points that should be addressed in your formal documents with your affiliates. Maybe it's an affiliation agreement. Some of these may fall into governing documents instead. But ideally, you're going to talk about in those documents an attribution of finances and resources, as Janice referred to, things like dues, how are we going to count dues, for instance, or if there's a license of the name, is there some benefit to the national for the right of a local charity, for instance, to use that name to solicit funds. Intellectual property obviously need a strong protection on the trademark and the copyright front, as we talked about. Insurance and liability protection, are we able to give benefits to a chapter, such as inclusion of the chapter on the parent's coverage? And if not, are we going to obligate the chapter to have its own insurance coverage, and to what level are we going to require that? Dispute resolution, disaffiliation, as Janice talked about. Tax exemption, making sure that the affiliate is staying in its lane when it comes to its tax-exempt status. Obviously, the actual activities, what are we saying we're going to do, and the governance structure. These are the sorts of things we're going to address in that document. I'm turning it over to Janice.
Thanks, George. We've actually addressed a lot of these issues as we've gone along, so I may just sort of touch on these things and highlight them, and maybe give my input on where we often recommend organizations, what kind of document they address each kind of issue. So in governance is important depending on the kind of relationship you want. If you want a parent-subsidiary, very closely controlled relationship, those control mechanisms need to be in the governing documents of your affiliate. If the parent is to be the sole member of the nonprofit affiliate, that needs to be in the affiliate's articles of incorporation. There are other ways that you can include parent control or oversight in the governing documents, perhaps The board of directors of the parent has some sort of right to approve amendments to the bylaws or articles of the affiliate. The important thing to note is that stuff has to be baked into the governing documents. If you're going to have requirements for the affiliate's governance structure, perhaps for nominations or elections to be intertwined with the representatives at the national level in terms of their governance, that stuff should also be part of the affiliate's governing documents in some manner, probably the bylaws. But this is also an appropriate place for up front, before perhaps granting affiliate status, you would have an affiliate charter or affiliate guidelines of some nature that says, if you want to be an affiliate of us, you have to meet these requirements, and you have to change your governing documents to include them. And we addressed some of the issues with common membership as well earlier about how it's important to be clear about what happens if you do require common membership and you're a membership organization, what happens if one is terminated from one organization. Those kinds of things should all be in the governing documents. As for finances and resources, this is stuff that's really important for an affiliation agreement. It doesn't necessarily have to be in the governing documents, but it's important to establish through your agreement proper cost allocation for shared staff, facilities, or other resources. This is necessary for tax implications. There are some potential unrelated business income tax implications for an organization that provides, if it was characterized as management fees to manage the related entity. You want to be able to avoid those consequences by providing a fair, reasonable allocation. That one entity can do it as an in-kind contribution, but you just need to record it as such. Otherwise, it really needs to be a reasonable reimbursement structure based on fair market value. Same goes for allocation of revenues and fundraising requirements. If you have specific fundraising requirements or expectations about how revenues are going to be shared, that needs to be documented in your affiliation agreement. Same goes for dues collection. I recommend internal controls being part of either your affiliate guidelines or in your affiliation agreement as well, just as for prudent purposes. And if you have a group exemption, the affiliation agreement, or perhaps you have a separate kind of agreement with your group exemption affiliates, you need to require the affiliates to provide annual reports to the central organization in order for the central organization to comply with its tax-exempt requirements.
Okay. And then on the purposes and activities front, you want to make sure that the affiliation agreement makes very clear that the affiliates are held to limited activities that will be consistent with your exempt purpose. Also, there may be some geographic restrictions if you have, for instance, chapters throughout the country, that their activities are within a particular chapter, that being the chapter themselves, not the members. We don't want to restrict the members where they can go if it is a membership organization. And then anything else that's going to be provided by the national to the chapter, just like any good agreement, that if you're going to provide services and be paid for it or otherwise receive benefit for it, let's get it down and documented. Obviously, from a tax exemption perspective, you're going to, if there is no group exemption, you're going to require that your affiliate maintain the proper exempt status. If there is a group exemption, you're going to require that they act consistent with that exempt status that they have and make those reports that Janice said. And as we pointed out earlier, those cost allocations are very important from a tax perspective as well.
Probably the most important terms of your affiliation agreement with your affiliate will be the intellectual property terms. This is the place where you will clearly establish who owns the trademarks, the logos, and what are the terms of use. How will the affiliates be permitted to use those marks? Same goes for membership lists and other copyrighted works. Establish in the agreement the ownership and the terms of use. As far as liability and insurance, these are other ideas that you may want to consider including in your affiliation agreements. Perhaps you want to have some sort of obligation between the parties for protecting the confidential information of the parent and the affiliate. You may want to have established in your agreement some limitations on the ability of the affiliate or the parent to speak on behalf of either entity. You may want to have an indemnification provision requiring either the entity or the parent to hold the others harmless for acts or omissions that they undertake. Now, most indemnification provisions are not worth very much without insurance. So you may want to also list what the expectations are for each party to maintain insurance, whether it's general liability, perhaps directors and officers, perhaps some form of errors and omissions. Just set forth what the expectations are. Is there an expectation of maintaining insurance? What kind? How much? And as far as affiliates, parent entities go, parents may want to offer an ability for the affiliates to participate in the national's insurance program of some sort, or they may want to provide some sort of service to procure insurance at reasonable rates on behalf of the affiliates.
Yeah, on that point, obviously the smaller the chapter, if it's a very small, unsophisticated, volunteer-run chapter, having indemnification and insurance may not be realistic. Of course, the larger the chapter, the more realistic it is. But like Janice said, and we'll focus on this in our program on insurance in October, it is very common for national associations to negotiate a special arrangement with an insurance carrier whereby all of the chapters can buy into a special kind of tailored insurance policy at a group rate, at a much better rate in order to do that. And that's frankly in everyone's best interest, the national and the chapter and the people that run the national and the chapter. It's in all of their best interest to be able to negotiate one or more insurance policies, D&O insurance, perhaps other types of insurance on a group basis like that.
Okay, and the last point on these affiliation agreements that we want to make sure we cover is a big one. It's dispute resolution and kind of disaffiliation. What happens when the relationship goes bad? And I would just say, having been through a few of these wars at times with between national and chapters, for instance, or an association and its related foundation, et cetera, most of these relationships, you don't want to go as far down this line as you can take it, but you need to have provided for in your agreement so that you know full well going in when you have a dispute or you have an issue that this is the process that you will follow. And oftentimes, particularly in a chapter situation, it's very beneficial and it's a good idea to have a process that may take a bit of a while. You have a probation or some form of notice proceeding, some kind of hearing process or something like that, just so the chapter or the entity can get its act together and give them that one chance. But ultimately, you have to be very clear, and we've talked about it in a number of different contexts, that part of that disaffiliation is the no longer allowing the affiliate to use your name, logo, or any intellectual property that you have. So it's written into the agreement. It's written into, we've got trademark registration. We've got all the protection in place so that ultimately if the dispute goes bad, you don't end up having this Northwest chapter of XYZ group still out there using XYZ's name and logo after you've got no affiliation. So then, this our last slide here. We want to talk kind of other points that, through our experience, we've gained some insights, we hope, and not necessarily from a legal perspective, although some of them are. It's real important if you have the ability to invest in the amount of staff and national headquarters support for your chapters and affiliates. Again and again, from the chapter's perspective, it helps with your relations with them and it helps with your relations with your affiliates, but it also helps you with your oversight and managing your liability so that you have someone dedicated, depending on the size of the organization, to really look at and oversee what's going on at the chapter or affiliate level. You probably all do board training for new board members of your organization when they come in, and maybe you do it for the whole board, which is great each year. But do you do the same training for your affiliates and your chapters? Particularly in the example we've been talking about here with smaller chapters, for instance. It's not as though they're going to have some professional staff or attorney or somebody come in and train their new board members each year. So giving them that training as to just general board service, but then overlaying that and what it means to be a chapter or an affiliate of this organization, what the affiliation agreement is all about, et cetera, very important and very helpful.
Yeah, to interrupt for a second, a lot of our clients have an annual conference where they bring in the leaders, maybe the chief executive officers, the executive officers, whatever they're called, from the various state and local affiliates, bring them to a several-day conference once a year. We frequently go and speak at those conferences on legal issues for all the state and and local chapters. They always seem to soak up that information because they just don't have access to those types of resources and that sort of expert information. Of course, we speak on legal issues, and other people come in and speak on a whole host of other issues. That we found it to be a very effective tool that national organizations can use.
Absolutely. And then the other point is more of a chapter or affiliate relations context is to the extent, my experience has been to the extent that affiliate leaders are included in the decision-making process before some decision is handed down to them, the more likely it's going to go smoothly and not have a lot of rancor from the affiliate ranks. Frequently, our nonprofit clients or association clients may have what they think is a great idea for a mutually beneficial new program that will involve the chapters or affiliates. But if it isn't properly vetted through the affiliate leaders, it often meets with distrust and a little bit of skepticism. The chapter relations is difficult to manage, I know, but including the affiliate leaders to the extent you can in that decision-making process will help. And I think we've already touched on the insurance issue to the extent we can really talk about it in this amount of time. But those are some of our kind of closing thoughts on the affiliate relationship. And I don't know if, Janice, if you don't have anything else, we ran over a little bit. I apologize for taking some of your time.
Do we have any, we don't appear at this moment to have any questions on the webinar that I haven't answered, but do we have any final questions here in the room? Seeing none, we'll stick around afterward if you have any follow-up questions. But otherwise, thank you very much for attending, and we hope to see you back next month.